James Stephen says that culpable homicide and murder is the weakest part of IPC. This culpable homicide and murder is the most important and most beautiful part of this IPC, which helps us to understand how this culpable homicide and murder is different. When human death can be called culpable homicide and when human death can be called this murder. To understand this culpable homicide and murder, we'll have to adopt a particular kind of approach. And in this approach, the first and foremost thing which we are required to keep in mind is that theme which we must have discussed several times, that all offences consist of two elements, mens rea and actus reus. When I say mens rea, you understand that I am talking of intention, knowledge, reason to believe, all the different sets of mind. Whereas when I say actus reus, it includes all the physical part of the crime. So similarly here now there is mens rea and there is actus reus. What is actus reus of culpable homicide? What is actus reus of murder? Actus reus in both cases is same, that is death. Causation of death. Death results in both cases because it is homicide, human killing, culpable homicide. So criminal human killing. And murder is the graver causation of death. It is graver than this culpable homicide. So obviously there is causation of death even in that case. Is this clear? So culpable homicide and murder, there is actus reus of death. Now what is mens rea? Now mens rea, if you see carefully, then it is defined in section 299 and 300 both. Culpable homicide and murder is defined respectively, and you find there mens rea. Now section 299 says, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that by such act he is likely to cause death, is said to cause or said to commit culpable homicide. So this is how section 299 defines culpable homicide. So mens rea is basically intention to cause death, intention to cause bodily injury as is likely to cause death, or knowledge that by such act he is likely to cause death. So what is the difference between 299 and 300? So difference lies in sets of mens rea. Now if I see 299, the first one, whoever intending to, whoever causes death by doing an act with the intention of causing death. And similarly we find there, now except in cases hereinafter accepted, culpable homicide is murder if it is done with the intention of causing death. So intention of causing death is there also, intention of causing death is here also. So there is no difference as such. So it becomes difficult for a beginner like us to find what is the difference. What is the scheme of this IPC? Is scheme in the mind of the makers of this IPC? What Macaulay wanted to say on the point? We'll understand this. And we'll understand this very, very carefully. And for that we'll adopt a particular kind of approach. And that is what we are going to discuss here right now. Very smartly and very carefully and very clearly. Because otherwise it will remain in the same kind of confusion which has prevailed in the mind of general people now generally. So let us understand first the concept of this culpable homicide. I will not divert much because it will not give you clear idea of the concept. So I am concentrating here only. Now let us see how it is done. Now culpable homicide. First let us understand this, then we'll understand. It says whoever causes death. So whoever causes death. So death must be caused by somebody. Then it says, by doing an act with the intention with intention. With intention of causing death. This is number one. And number two, this is number one. Number two, with the intention of causing bodily injury as is likely to cause death. As is likely to cause death. And then third, it says, or with the knowledge that by such act he is likely to cause death. Knowledge that he is likely by such act to cause death. Knowledge that he is likely by such act he is likely to cause death. I've changed the words, no issue. It remains almost similar. So in first it is intention of causing death. In first it is intention of causing death itself. The second it is intention of causing bodily injury. No intention to cause death here. Just find the reference. And here it is knowledge that by such act he is likely to cause death. So there are three different sets of mens rea. Three different sets of mens rea. Three different sets of mens rea. Can you see this? Intention of causing death, intention of causing bodily injury, knowledge that by such act he is likely to cause death. Can you see this carefully? All right. All right. So you understand this is actus reus and this all is mens rea. So this is clear, actus reus plus mens rea. Is this clear? The first point is clear to you. If this is satisfied, this is culpable homicide, this is criminal human killing. Understand. All right. Let us proceed further. See, it says whoever causes death. So first and foremost, death must be there. Death means, as per section 46 of IPC, death means death of a human being. So if it is death of a animal being, it is not culpable homicide. It has to be death of a human being. Is this all right? It has to be death first. Then second, there has to be causal connection between death and whoever, that is the criminal, the accused. If this causal connection is missing, you cannot charge me for death. You cannot charge me for the offense. So second is causal connection. Now many questions will be answered on this basis that there is some missing causal connection and we cannot establish causal connection, so we cannot charge you for culpable homicide or murder. Must understand this. Many people will now create, or many people will be in some kind of problem here on the point of causal connection. Suppose A has given injury to B and B is being taken to hospital by an ambulance. Now, due to negligence of ambulance driver, ambulance meets with an accident and the patient dies. Can it be said that the person who caused injury, he has committed death? No. Suppose similarly A causes some injury to B and he is being taken by an auto rickshaw and a tree falls on auto rickshaw due to some kind of a storm, etc. and the person dies then and there. Can it be said that the person who caused injury, who caused hurt, who caused grievous hurt, whatever, he has caused death? No, because causal connection is missing. Must understand this. Clear? So death is number one, ingredient, causal connection is second. If causal connection is not established, you will have to establish. And this is the reason why we look for motive. Whenever the crime is committed, police wala looks for motive, meaning thereby who will profit from the crime, why he might have killed. So they want to find some kind of connection between the criminal and the offense. You try to understand this point. So whoever causes death by doing an act with the intention. Now the third, intention to cause death. Intention to cause bodily injury. Now see how Lord Macaulay is smart. He doesn't say mental injury. He says bodily injury. So you cannot cause death by mental injury as far as section 299 is concerned. And then third, he says knowledge. Every sane man is presumed to know the natural consequences of his act. Knowledge is presumed. Knowledge that by such act is likely to cause death. So not very grave, likely to cause death. So if these three are satisfied, then we can move further. If these three are satisfied, the case falls in section 299. How will we know this intention? How will we know this intention? How will we know this knowledge? We'll come to this little later. Don't worry. But you first understand the scheme of drafter of IPC. Is this clear? First, death has to be established. For establishing the death, you must need some kind of identification of dead body. Dead body should be recovered. Then it should be identified that this is the victim who died. Now, post-mortem report, etc. All these things are done. Then causal connection, I have already told you, you are required to establish causal connection between the death and the accused, the criminal. And then you are required to look for this intention to cause death or intention to cause bodily injury or knowledge that by such act is likely to cause death. If these three are established, and then we'll move further. Then what is the next stage I tell you just now? See how I'll move. I am moving slowly and steadily. So first is the death. Second is the causal connection. Is this clear? Third is that the case will come in section 299 or the case will go in section 300. Now just to understand this point, I must tell you, this was number 1, this is number 2, this is number 3 step, this is number 4 step. You understand this? Step 1, step 2, this is 5-stage inquiry or 5-step inquiry or step 4. And then we'll come to step 5 also. That is exception. Is this all right? So now, section 299. I begin with section 299. First one is intention to cause death. It will make your task simpler, general, the method which I have adopted, you can do it quickly. Now let us see section 300. It says, except in cases hereinafter accepted, culpable homicide is murder if the act by which death is caused is done with intention of causing death. Intention of causing death. Now tell me, you find any difference between the two? That is with the intention of causing death. Here also intention of causing death. Do you find any difference? Here and here, the same words. Death has occurred, causal connection is established, the case is here, and the same case is here. So what is the difference between 299? For the purpose of convenience, I must tell you what Supreme Court has done, that they have adopted an approach to solve such query, that they will go this first in 299 and then they will visit 300 and they will come from top to bottom, left to right. Top to bottom, that is top to bottom means top is this, then second, then third. And left to right, this is left, this is right. Left to right. Left to right. Can you understand this? And top to bottom. So, for the purpose of convenience, they have divided this into A, B and C. And here they have done it 1, 2, 3 and 4. This is already done. Firstly, secondly, thirdly, fourthly. This is done in your barrack. This is done in your IPC, but this is A, B, C. So, top to bottom, left to right. So, top to bottom, left to right. So, first I will come in this. Death is there. I have established step number 1 over. Stage number 2, this is over. Causal connection is established. Now, we come to step number 3 or stage number 3. Intention of causing death can be seen there. How to assess that there was intention to cause death? How do you read intention? I tell you, the test of intention is, and you know, I hope you know about intention. What is intention? Intention is basically cognition plus volition. Cognition plus volition. I will write here and I will remove it just for your convenience, because I have to write 299 ABC, so I will remove it later on, but here I am writing it right now. Just I am writing it here and I will remove it later on for your convenience. So what is intention basically? If a question is asked, what do you mean by intention? So intention basically means cognition plus volition. Cognition means both and volition means iksha. So you have this cognition, you have understanding, and then you desire. So you know of the consequence and then you desire the consequence, and that is intention. So what is intention? Intention is that situation where one knows consequence of his conduct and desires the consequence. So not only you know, you desire also, see. So cognition means now you know, and volition means you desire. Cognition means, volition means you desire, and cognition means you know. So what is intention? Intention is basically cognition plus volition. So if I have this knowledge that if I hit somebody with a pistol, I fire a pistol on somebody, I fire a gunshot against somebody from point blank range on the vital part of his body like head, etc., I'll be killing him. I know this and I desire his death and I do this act. So what is this? This is intention. So whether there is intention to cause death or not can be assessed from your conduct. There is basically formula of backward integration. We see your conduct and from your conduct we'll read the intention. Oh, तुमने गोली चलाई, point blank range से चलाया. You fired a gunshot, and that too from point blank range. So what may be your intention? What may be your desire? आपकी इच्छा क्या थी फिर? आप क्यों चलाए गोली? Why did you fire? What you intended? You intended death, nothing else. That's all. So that is intention to cause death. If I beat somebody mercilessly, like now Taliban has now mercilessly thrown stones on a person where there are hundreds of people harrowing him, and they are standing around him and they are throwing stones on him till he dies. So what is their intention? Is there no intention to cause death? I firmly believe there was intention to cause death. So you cannot make a mechanical formula. If somebody has been hit by stone, then it is no intention to cause death, and somebody is hit by gun, then it is intention to cause death. No, there can be intention to cause death when you fire a gunshot against somebody. There can be intention to cause death when there can be a lathi blow. Mercilessly you have been beating a person till he dies. So what is your intention? Your intention is to cause death. If you are throwing stones, thousands of people on a person, what is your intention? If you throw a child of 6 months into a river, what is your intention? If you give now a snake bite to somebody, when you know that the snake is poisonous, venomous, so what is your intention? If you give poison to somebody so that he may die, what is your intention? What is your intention? I can't say that your intention is anything else apart from intention to cause death. So your intention is to intention to cause death. That's very clear. Your intention is to intention to cause death. Is this all right? So intention is basically cognition plus volition. That is your intention. That is your intention. Is this clear? Is this clear? Now, so you understand little bit what is intention. Intention is basically this cognition plus volition, that you have understanding of the thing and you desire the thing. You have understanding of the thing and you desire the thing. Is this clear? You have understanding, you have knowledge. Cognition means both. Knowledge. You have knowledge. So knowledge and desire. If I have knowledge, then it will fall into 99C. I do not desire death, then it will not fall in this 299. Is this clear? I have intention to 99A, I have intention to 99B, I have knowledge to 99C. Is this clear? So now just to understand first, before I move further in this debate of 299 versus 300, which I will be covering up, let us see this 299 illustrations just to make you comfortable with 299. A lays, now this is how Macaulay makes you understand the law. Now this is 299 illustration A, which you should read for your proper understanding. This is another problem, that people generally do not read illustration and they never understand. I will suggest the lawyers, and I will suggest the students, and I will suggest even others, those who want to understand this, that they must read illustrations carefully. Many of illustrations make your point very clear. Like in theft, I had a debate with a lawyer, senior lawyer, that now when the property is moved only in your house, it cannot be theft because property is not taken out. But I told him, you read section 378, it says when the property is moved in order to taking, this completes theft. So you must understand those things. Illustration H in section 378 is there, which makes this point clear. Illustration H to section 378. You just see this. But let us come here in 299 illustration A. Let us read this illustration for proper understanding. A lays sticks and turf over a pit with the intention of thereby causing death. With the intention of thereby causing death. Or with the knowledge that the death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in and is killed. A has committed the offense of culpable homicide. Because he has intention to cause death. Or he knew that the death will be caused. Lays turf over a pit. So there is a hole. And you have created an impression, a false impression, that it is solid ground, which is not there. So if somebody treads on it, he is going to fall into it. So he will die. So intention to cause death can be inferred from your conduct. This is what I said, that there is theory of backward integration. You see the fact, you see the act, and then you read the intention. So this is called theory of backward integration. We read the act, we read the conduct, and then we see the intention. So that is how Macaulay has written beautifully. Now, and see, your intention is wrong, that is to cause death, and that is why. See again, illustration B. A knows jet to be behind a bush. A knows jet to be behind. A knows jet to be behind bush. B does not know. A intending to cause, or knowing it to be likely to cause jet's death, induces B to fire. B fires and kills jet. Here B may be guilty of no offense. Why? Because B is innocent. B does not have any wrongful intention. B does not know that somebody is there behind the bush. But you know this fact. So you will be held liable. You will be held liable. And I tell you, Lord Macaulay very clearly clarifies here that innocent intervener or intervention of an innocent agent does not break the chain of causation. This clarifies the chain of causation. A intends to cause death of jet. He induces B to fire. He knows that jet is behind the bush. B does not know. B is innocent. A is criminal because he is entertaining a wrongful intention. So now when A asks B to fire, on that particular bush, he knows that somebody is behind the bush. Who is criminal? Who has wrongful intention? A has wrongful intention. B does not have wrongful intention. So can you make B liable for culpable homicide? The answer is no. It is who is liable? It is A who is liable. So now innocent intervention or intervention of innocent agent, like here in case of B, does not break the chain of causation. A is having wrongful intention and A has invoked an innocent agent, but that doesn't matter at all. A is liable as a criminal. He has wrongful intention, and we are just explaining the fact that A will be held liable for culpable homicide because B is innocent. B does not break the chain of causation. But see, in contrast to this, illustration C very beautifully Macaulay says, A by shooting at a fowl with intent to kill and steal it. Fowl kills B who is behind a bush. A not knowing that he was there. When A does not know that B was there, can you make A liable for killing of B? He wanted to steal. He wanted to shoot at a fowl with intent to kill and steal it. He doesn't want to kill a human being. A not knowing that he was there. He doesn't want to kill a human being. He doesn't know this. So does he have criminal intention, tell me, to cause human death? No. So can you make him liable? No. Here, although A was doing an unlawful act, his act may be wrong, his act may be unlawful, but has he committed any offense of culpable homicide? As he did not intend to kill B or to cause death by doing an act that he knew was likely to cause death. No, not at all. He is not intending to kill the person there, kill B there. So can he be held liable? The answer is no, not at all, not at all. If there is absence of mens rea, there can be no culpable homicide. There can be no culpable homicide. Is this clear? So Lord Macaulay clarifies several points in 299. First, he says that it may be intention or knowledge, we are not much concerned. If there is intention to cause death or knowledge that by such act he is likely to cause death, in both cases he has committed culpable homicide. In illustration B, he clarifies that innocent intervener does not break the chain of causation, A will be held liable because he is possessing criminal intention to cause death. In illustration C, he says he does not have criminal intention to cause death of a human being, or he does not know that by his act he is likely to cause death of a human being. He is intending to kill and steal now a bird. So how can he be held liable for human death? This is unbelievable. So we cannot make him liable. So 299 is preliminary. You understand the preliminary point first. Now intent, you understand intention to cause death, you understand. Lord Macaulay further clarifies the point. I have just stopped here. I'll continue. I'll begin from here again. Lord Macaulay again clarifies the point in explanation 1, 2, 3 very beautifully, and it's very small points. I must read it for you. A person who causes bodily injury to another whereby he accelerates death when he is laboring under disorder, disease or bodily infirmity, thereby accelerates death, shall be deemed to have caused death. So you have no one to accelerate death. If I have to live for 10 days, why did you kill me in 1 day? Why do you want to accelerate my death? So acceleration of death is causation of death. Beautiful point. Acceleration of death is equivalent to causation of death. This is explanation 1, 299. Is this clear? Now let us read explanation 2. It says, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused death, although by resorting to proper remedy and skillful treatment, death might have been prevented. So proper remedy. India is not so rich country. And a proper remedy and a skillful treatment to save life is not excuse for murderer. For, I do not use this word murderer, for offender, for accused. Is this clear? Explanation 3. It says the causing of death of a child in the mother's womb is not homicide. Because in India, you know, till the child has taken birth, it is not considered an independent human being. General law is this. English law is very clear on the point. Till the child completely comes out of mother's womb, जब तक शिशु पूरी तरह से माँ के गर्भ से नहीं आ जाता, तब तक वो मृत्यु का विषय वस्तु नहीं हो सकता. Till the child completely comes out of the womb of mother is not subject matter of death. That is very clear in English criminal law. अंग्रेजी दंड प्रावधान जो है इस पे बहुत स्पष्ट है. बट भारतीय दंड विधान में, in Indian penal court, English penal code, you understand, in English penal law I said, unless until the child completely comes out of the womb of mother is not subject matter of death. But in India, the law is a little bit now different on this count. And it says that the causing of death in mother not homicide, but it may amount to culpable homicide if any part of child has been brought forth. So, if any part of child has been brought forth, then it becomes subject matter of culpable homicide. Any part. Any part. So, Indian criminal law is a little different on this point. If any part of body has come out, it is subject matter of death. Any part. Though the child may not have breathed or been completely born. So, any part of child body which has come out of mother's womb makes it subject matter of death. makes it subject matter of death. Any part of child's body has come out. Though it has breathed or not, that is a different matter altogether. Complete birth is not necessary. Complete birth is not necessary. I hope you listen to me carefully. Complete birth is not necessary. Any part of child's body has come out of mother's womb, it is sufficient. It is sufficient. Is this clear? It is sufficient. It is sufficient. So, the explanation one says acceleration of death is causation of death. Resorting to proper remedy and skillful treatment is no defense. And third, part of child body has come out, that is also subject matter of death. That is also subject matter of death. Otherwise, till there is no birth, no, it is not subject matter of death. Then the mother's death will be there, child's death will not be there. Now, if a pregnant woman is killed, then it is culpable homicide of that woman and not of child. Is this clear? So I hope you understand section 299. It's 3 sets of intention. You understand the actus reus death. You understand the 3 sets of mens rea. You understand 3 explanation. Very simple. The first one was related to turf. The second one was related to this bush, where the person is behind bush. And third one is related to this fowl, that is stealing of fowl. And that is how you can remember the things also. If you have now this desire to memorize everything, you can do it. Accelerates explanation 1, treatment explanation 2, child is explanation 3. You can pick up the key words of the particular provision. Is this clear? Now, let us proceed further. Is this clear? Now then let us then you must understand what I said. In this journey of 5 stages, stage 1 was death. Stage 1 was death, and death means death of a human being. Clear? Section 46. Clear? Stage 2 I said causal connection. So connection is must between offender and offense. Third, stage 3, where I have come in this section 299 and section 300, and I said that here there is intention to cause, intention of causing. What is written there in bare act? Intention of causing death. I will not change words. And here also intention of causing death. So now, I began my journey here and I said that, see, what is intention? So I have clarified little bit what is intention. What is intention? I said cognition plus volition. Intention have different sets. Intention, mens rea has different sets. Intentionally, knowingly, maliciously, malignantly, fraudulently, dishonestly. There are many sets of mens rea. We are not concerned with that right now. But you must understand what is intention. So I hope you have understood intention. Intention is anything you know and then you desire the consequence. All right. But it is same. So how to differentiate between 299A and 300? Firstly, what is the difference between the two? This question has vexed many people. What is the difference between the two? I tell you, my dear friends, there is no difference between 299A and 300 firstly. There is no difference. कोई अंतर नहीं है. तो फिर कैसे? How? I have read that there are so many differences. No, there is no difference at all. whatever case will come here in 299A and this intention of causing death, intention of causing death. So whatever case comes here in 299, it will automatically fall in 300 firstly. There is no stopping here. Is this clear? Is this all right? So whenever a case will come in 299A, it will automatically go in 300 firstly. So there will be no case in 299A. So do you want to say that 299A is redundant provision? No, no, no. Whenever a case will go in 300 firstly, then it has to cross the hull of 299A first. It will go always like this. First it will come in 299A and then it will go in 300 firstly. So it will move always like this. So if it doesn't come here in 299A, how will it will go in 300 firstly? It has to be always left to right, left to right. So first it has to be culpable homicide and then it has to be murder. Is this clear? Is this clear? Is this all right? Now, so then what is the utility of 299? I said there are two utilities of 299A. One, that the case will not go in murder unless and until it is in culpable homicide. It is in culpable homicide. Is this clear? Number one. Number two, if the case goes in 300 firstly, if the case goes in 300 firstly, and if it falls in any of the exception, then where will it go? It will come back to 299A. It will come back to 299A. So if 300 firstly falls in exception, any exception given here, then it will go in 299A. Is this clear? Is this all right? Then suppose the case is not covered here and it falls in 299B. There was no intention of causing death, but there was intention of causing bodily injury. There was intention of causing bodily injury. Intention of causing bodily injury. Intention of causing bodily injury. Now in that situation, what will happen? Intention of causing bodily. Achha, how will you know that this is intention of causing bodily injury? So where there is no intention of causing death and there is intention, so what is that intention? Intention of causing bodily injury. Bodily injury, not mental injury, I said even earlier. What is injury? You know, injury is defined in IPC in section 44, which says that there are four kinds of injury. 44 talks of four injury. Injury to body, mind, reputation or property. body, mind, reputation or property, 4 kind of injury. So this is not injury to mind and reputation and property, this is bodily injury. The Lord Macaulay is very now sincere in writing. So he says this is intention of causing bodily injury. Now somebody has bitten some other person, he has given grave injuries, now by farsa, garasa, bhala, there are different weapons, lathis, now different weapons. He has given him grievous hurt, which is now such which can cause death. Intention of causing bodily injury as is likely to cause death. Intention of causing bodily injury as is likely to cause death. Now you are not sure exactly, but it is likely to cause death. Likely to cause death. Intention of causing bodily injury as is likely to cause death. You are not sure, you are not certain. Here you are certain, but here it is likely. It is not so certain. The gravity is a little lesser. The degree is a little lesser. Likely to cause death. Now, if the case falls in 219, I'll explain it even further, but just here to tell you further points. Now, this can go in 2 different directions. Here your understanding is very, very important. You must understand the point which I am going to make, and this is how you will understand it better. If you see 300 secondly, so what it says in 300 secondly here, intention of causing bodily injury is likely to cause death. Intention of causing bodily injury. It says in 300 secondly, if you see carefully, it says, if you can see 300 secondly carefully, it says if it is done with intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. So what is the aggravating factor? Intention of causing such bodily injury. Intention of causing such bodily injury. Not all bodily injury, such bodily injury. All right? Such bodily injury as the offender knows. Now, every word is very important. As the offender knows to be likely to cause the death of the person to whom the harm is caused. Now see here, it is intention of causing such bodily injury as the offender knows. So here there has to be a particular offender. Cause the death of the person to whom the harm is caused. Now you see the use of the definite article the. Intention of causing bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. What is the significance of use of this the time and again? I tell you. Now what makes it graver? How the case from 299B goes to 300 secondly, there is a reason. What are the aggravating factors? I must tell you, what is the aggravating factor here? The aggravating factor is, the special knowledge which the offender has. The particular knowledge of particular element of particular victim which is known to a particular accused. So the particular accused knows of the particular element of particular victim. So this particularity of knowledge, of particularity of element of particular victim makes it graver and more criminal. Makes it graver and more criminal. Makes it graver and more criminal. Is this clear? Is this all right? Makes it graver and more criminal. अब देखो मैं बताऊं इसका बहुत केसेस में, अब मैं अभी नहीं जाता, आपको समय बहुत लग जाएगा, मैं केसेस में बाद में आऊंगा, बट जस्ट आई टेल यू हियर वेरी ब्रीफली माय डियर फ्रेंड, you know of Mahabharata. Who knew where Duryodhana is to be hit? So if you know where Duryodhana is to be hit, you are the culprit. You can hit him there. So you are the particular person who has knowledge of particular element of particular person, particular victim. So if Bhima knows about that particular fact, the Krishna knows about the particular fact, so they are, in that sense, the persons to be covered here. Is this clear? So intention of causing such bodily injury, not all, such bodily injury, as the offender means particular offender, knows to be likely to cause the death, not all death, not death of everyone, the death of the person, that particular victim, to whom the harm is caused. To whom the harm is caused. Is this clear? Now see further. This is 299, or this is 300 secondly. This was 300 firstly. Now when the case will go in 300 thirdly, so the same bodily injury which has resulted into death, this will take the case into thirdly also. But when? So there are different situations for that. You read thirdly. It says, if it is done with intention of causing bodily, see here, intention of causing bodily injury. Here it is not such bodily injury. Here it is bodily injury. Such is not here. Causing bodily injury. See the use of word. To any person. Any. Not the. The death of the person. The person. You just see it carefully. Here it is written the person. And here it is written any person. Here it is written such, bodily injury, such. And here it is written only bodily injury. Intention of causing bodily injury to any person, and the bodily injury, this is the second part, the bodily injury intended to be inflicted is sufficient in ordinary course of nature Now see, what is the difference, I tell you. It says intention of causing bodily injury to any person, This is clear. Intention is to cause bodily injury to any, and the bodily injury intended to be inflicted, it should be intended bodily injury, is sufficient in ordinary course of nature to cause death. Here it doesn't say cause death of the person. It says to cause death. To cause death means cause death of any person. So to cause death means cause death of any person. Is this clear? Cause death of any person. Intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in ordinary. So, whenever there is a case in 303, the inquiry is like this, that there was intention of causing bodily injury, which can be caused to anyone, but the injury which has been caused, the bodily injury, this should have been intended injury. This should have been intentional injury. If the injury which has been caused is not intentional but accidental, 303 will not apply. 303 will not apply. The injury which has been inflicted should be intentional. The bodily injury intended to be inflicted. So, injury which we see on the body of a human being should be intentional bodily injury. Should be intentional bodily injury. Is this clear? It should be intentional bodily injury. It should be intentional bodily injury. Otherwise, this will not be covered in 303. Intended. The bodily injury intended. So it should be intentional bodily injury. So this is subjective. This part is subjective inquiry. That whether the accused intended this injury or not. This is now subjective inquiry. Whether the accused intended to cause this injury or not. If you fail to prove this as prosecution, you cannot bring this case in 303. To bring the case in 303, it is must that the injury which is there on the body part of dead person should be intentional injury. You will have to prove this. And then when you have proved this intention, then the second part comes. It is sufficient in ordinary course of nature. It is sufficient in ordinary course of nature. It is sufficient in ordinary course of nature to cause death. It is sufficient in ordinary course of nature to cause death. It is sufficient. So this injury which is there, it's sufficient in ordinary course of nature to cause death. Ye sufficient hai. This is sufficient injury. So sufficiency of injury is objective inquiry. Sufficiency of injury is objective inquiry, whereas bodily injury which is intended to be inflicted is subjective inquiry, that this was the injury which was intended. If it is accidental, 303 cannot be invoked. Because it says very clearly, now this should be intentional injury, it should be intended injury. Is this all right? 303, are you clear of this? 303 has two parts. And the bodily injury intended to be inflicted. This is subjective inquiry, sufficient in ordinary course of nature to cause death of any human being. Any human being. It is not like 330 that it should be a particular. Any human being. 330 is any human being. Death of any person. You can write here. Death of any person. Any person. I have added. Death of any person. Any person. Is this all right? Death of any person. Then let us proceed further. Now there is no space here, so I'll use above space. Now come to 299C and the 304th. I hope you understand 299A, 301st, 299B, 302nd, and 303rd. Now let us proceed further and let us see this, how it figures out 299C, what it says exactly. Let us see 299C, what it says exactly. You just see into 99, see what it says exactly. It says with the knowledge that he is likely, sorry, so what it says that with the knowledge that he is likely by such act to cause death, with the knowledge that he is likely by such act to cause death, that is oh, it is disturbing that with the knowledge that he is likely, with the knowledge that he is likely by such act to cause death. With the knowledge that he is likely by such act to cause death. Now, when I can say that the knowledge, in knowledge part there is no, in knowledge part there is no volition. कोई volition नहीं है इसमें. There is cognition but not volition. Knowledge means cognition. I know. I have that cognition. I know. Knowledge. That he is likely by such act to cause death. He is likely by such act to cause death. With the knowledge that he is likely by. So, how can I say that there is knowledge? Every sane man is presumed to know the natural consequences of his act. Every sane man is presumed to know he has knowledge or she has knowledge. See, if I keep a snake which is venomous on your head, I will be presumed to know. I will be presumed to know that this snake can bite this person and he can die. I will be presumed to know this fact. I will be presumed to know this fact. Because obviously the snake can bite anyone. Is this clear? With the knowledge that he is likely by such act to cause death. He is likely by such act to cause death. So knowledge is that presumption which law will presume regarding everyone, that you know that this is going to be the consequence. If I, in one case what happens that there are two children who are playing together and one hits another and he becomes senseless, the other one becomes senseless. And the mother of the child who has hit him, she thinks that he has done some mischief and he died. She doesn't care to check about his conditions, whether he is died or whether he is dead or alive. She throws him into a nearby nala just to save her own child. And now the child dies due to drowning in Nala, and post-mortem report comes and which says that child died due to drowning in Nala. So whether this lady will be presumed to know the natural consequence of her conduct, this is gross negligence on her part. So she will be presumed to know the natural consequence that if you throw a child into Nala without examining whether he is dead or alive, are you not committing this kind of gruesome, culpable homicide? Because even if somebody is dead, you take him to a doctor and he is declared brought dead. He is declared brought dead. So why not here? Why did you not examine? Because you were so careless. You are so grossly negligent. So gross negligence is nothing but knowledge. So law will presume knowledge in such case, and you will be imputed with this knowledge and your case will be covered in 299C. The snake charmer, he knows that the snake is venomous and he is keeping on the head of a spectator just to show his skills, that he will not bite you or snake will not bite you. And unfortunately snake bites and the person is killed. 299C is attracted. 299C is attracted. The moment case comes in 299C, then it will go in 304thly. And we'll see whether the case is well covered in 304thly or not. So let us see 304thly in this particular part. 304thly, what it says? It says if the person committing the act knows that it is so imminently dangerous. Knows that it is so imminently dangerous. Knows that it is so imminently dangerous that it must in all probability, it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. If the person committing the act knows that it is so imminently dangerous. What dangerous? It must in all probability cause death. Knows that, 304thly, knows that it is so imminently dangerous . It is so imminently dangerous that it must in all probability. See, in all probability, now chance of death is very, very grave here. So imminently dangerous that it must in all probability, puri sambhavana, in all probability, cause death or bodily injury. And that too without any excuse for incurring the risk of causing death. Without excuse. Now what is this without excuse? I'll let you know. Without excuse, causing death or bodily injury without excuse. Without excuse for incurring the risk of causing death. Without excuse for incurring the risk of causing death or such injury as aforesaid. All right, I tell you, what is this all about? in all probability causing death, bodily injury without excuse. Now see, imminently dangerous, that it is very dangerous. Like I said, snake bite, it's very dangerous. But here there is an excuse. What is the excuse? The snake charmer was not interested that the spectator should be bitten by that snake. He was interested in showing his skills of controlling the snake. And he has been doing it for past many months and he has been successful. There has been no snake bite as such. But unfortunately it happened today. So there was a kind of excuse available with him. If there would have been no excuse, then the case will fall in 304thly. So imminently dangerous, that it must in all probability cause death or without excuse for incurring the risk of death or injury. So I hope you understand this point. Basically, I have explained how this. Now see, death was the first stage, causal connection is the second stage, 299, three intentions are the third stage, 304 clauses are the fourth stage. And now even if the case is covered in 300, then it can go into again exceptions. And there are exceptions here written in your section 300. Exception of grave and sudden provocation. Exception of grave and sudden provocation when culpable homicide is not murder. This is not culpable homicide. This is not murder basically when it falls in grave and sudden provocation. Then this right of private defense. Then doing something under law. Then fourth is sudden fight. And fifth is this consent, death by consent. So in these five situations, there can be murder, but this murder will be converted into culpable homicide, not amounting to murder, for the simple reason that there are certain extenuating, mitigating circumstances. See, the murder, which is murder of a person who has gravely provoked you, should be treated with cold-blooded and hot-blooded murder. Should it be treated at par? No, that is what is exception 1. That is why it says grave and sudden provocation. Grave and sudden. Now, if I am gravely provoked, suddenly provoked, and during the provocation stage, I do something wrong, will you treat me in the same way? No, no, you will not treat me in the same way. Right of private, I exceeded the right of private defense, though I had right of private defense and I committed a mistake. No, the law has given me right of private defense and I exceeded my limit. So will you punish me in the same way? So you give me little bit concession. If anything is being done in obedience to law, and then in that doing of that thing, something wrong has been done, so will you punish the person in same way? No. Sudden fight, achanak. Now this has happened suddenly. And death by consent, where victim has given consent of his or her death, then will you treat them similarly? The answer is no. So this is what is the journey of culpable homicide and murder. And I think that you will understand this very carefully when you listen to this lecture time and again. More lectures will come, but you please watch this lecture carefully time and again to understand this point. This is very, very necessary to understand the fine distinction between section 299 and 300. Is this all right? Good. Thank you very much for watching me and for listening to me.